Hi, it's 1 o'clock, almost. We'll begin in a couple of seconds, so you can test if you can hear my voice. I'm Tony Karekis, the moderator. So today, we're here to talk about independent contractors versus employees. So in this session, we're going to have both the legal and the HR perspective. Christine Holmes is going to present the legal perspective. Christine is a lawyer and former in-house counsel at Cineplex Entertainment and PepsiCo. She left in-house counsel and founded Lawyers In-House, a virtual law firm comprised solely of in-house counsel, and they provide business practical legal advice and work with companies of all sizes, from startups, scale-ups to large enterprise. Jelaine Parks is the founder of Sprig HR. As a senior HR professional with over 25 years of direct HR and organizational development expertise, Jelaine has held senior leadership roles across a number of high-profile organizations, including Lavalife, Canadian Tire, Bombardier, and Cineplex. For the last 10 years, Jelaine and her team have been intensely passionate about delivering a performance management experience to clients that is clear, simple, and cost-effective while reflecting current trends and industry needs. And I'm Tony Karekis, also of Sprig HR, and I am your moderator. At the top right corner, you'll notice a box that looks like the one below. If you have trouble with audio, you can join in via phone, and there's phone numbers and access code provided. Also, if you have questions in the same box, you can expand it using the red arrow, and a box will open that says questions, and in there you can type questions. We welcome your questions. It will make it a better and more informative session, and we will answer those later in the webinar. We'll be collecting them throughout, so please feel free to send them to us as you think of it, and then at a natural point near the end, we'll respond to them. Today's broadcast is going to be provided to you. You'll get the slides, and you'll also get a link to the recording itself if you wish to share it or watch it later on. Let's talk about what we're going to cover in the next hour. First, the definition of what's an employee versus what's an independent contractor, the benefits of hiring an employee or an independent contractor, which is a better route for HR and organization, the legal classifications, legally what defines an employee versus an independent contractor, and then the risks of getting the classification wrong. And this has been a hot topic in the last number of years, lots of rulings, which we'll talk about both in Canada and the US, and the importance of getting it right and doing it right. And at the end, we'll have time for some questions and answers. Take it away, Jelaine.
Okay, thanks, Tony. So Jelaine Parks here, and we're here for our second broadcast with Christine Holmes and with Tony. Today, I'm going to kick things off actually just by beginning with what are just some essentials around highlighting the key differences and definitions, essentially, of what an employee and an independent contractor actually look like. We know one thing for sure in terms of their differences, which I'll outline in a moment, but one thing that they actually share in common is that they all need to know what their rights and responsibilities are when it comes to having a work relationship. So when we look at employees, I mean, any of us who've ever held a full-time permanent position know that we are covered by things like common law, employment legislation, ESA, or the code, which includes and is extended to us in the way of minimum wage, upsides in overtime, termination, leave, holidays, notice periods, etc. Again, full-time permanent employees by status are typically extended the workers' comp legislation, operate within those parameters, and they typically have an exclusive working relationship with their employer. And we're going to actually dig in a little bit to that whole exclusivity thing in a few minutes as it relates to the independent contractor. But again, an employee has typical obligations or really has the adherence to a code of conduct in an organization, the company policies, procedure manual, the house rules, essentially. And we all know, in terms of any of us who have ever had a contract, or rather not a contract, but a paycheck, I should say, we have all of our source deductions. And that includes the breakdown of the obvious, like tax, income tax, CPP, employment insurance, that are automatically taken and deducted from your pay, for which your employer has an obligation for remittance. And then again, typical scenarios for the employee would be having an employer paid benefit coverage, sometimes in part, but it usually covers things under healthcare, sick leave, short-term, long-term disabilities, pension plans, and in some cases, the professional development side. We cannot claim income tax or tax benefits that the independent contractor would. So in a lot of cases, we can't, for example, claim our mileage and getting to the office, albeit that very little these days. And then when we look at the independent contractor, we can interchangeably use the terms of being self-employed. And therefore, with that status, that very specific work status, they cannot and are not covered by the employment legislation. And they have their own obligations in arranging for pay of insurance or any sort of work-related coverage. And they actually don't have the same obligation that most employees do, which means they can work for multiple organizations. And again, Christine and I are going to have quite a bit of dialogue as we go through this topic today about what that looks like, and the obligations, again, of working for many employers versus just the sole relationship. So no source deductions, as we know, for independent contractors. They submit their invoice, and they are completely individually responsible for covering their own income tax, CPP and EI in those instances, and of course, their own benefits coverage. They are and are acceptable in terms of the claims, or within reasonableness of submitting business expenses under that working relationship or being an independent contractor. And they can make those deductions accordingly on their annual income or their annual tax income. So those are really sort of the key differences between the two work statuses or employment statuses. And when we now look at this through the lens of a company, and then the upsides of those people or bodies, we can say that for employees, they have the, from a company, again, from a company perspective, and hiring an employee has the upshot of tenure. So companies can secure talent within a position, the subject matter expertise. There's again, an upshot or upside of having a consistent approach, the rigor and the consistency around communication and providing clarity of conduct and expectations as an employee within a company. And then there's a lot less risk, of course, within the reclassification. So it's highly unlikely in the instance of an employee status that the CRA will walk in and attempt to flip that employee to an independent contractor status. And then when it comes to hiring an independent contractor, again, looking through the lens of the benefits of a company, the upsides are pretty obvious. I think a lot of contractors are sought out actively by organizations or by employers, mostly because of the cost effectiveness in doing so. Now, they aren't always required, of course, to be paid benefits, usually never. And then the payroll deductions aren't an obligation for the employer at that time either. And there's a lot more flexibility in terms of your labor requirements and thereby your cash flow fluctuations. So you can pick and choose that relationship, and they can come and go just based on the actual agreement itself and the length of that agreement. So as again, we're going to have quite a bit of dialogue during this session today, but Christine's going to now actually jump in and talk to us about some of the legal classification and the tests therein. So Christine, would you like to join us?
Absolutely. Thanks, Jelaine. And thanks, Tony, for the introduction. And good afternoon, everyone. I hope everyone is keeping well as you can be in these difficult times. And thanks for taking an hour out during these challenging circumstances and joining us for a conversation today. And thanks, Jelaine, for going through some of the key differences between employees and independent contractors and some of the different qualifications of each and classifications of each. So legally, how is the law interpreted it? So there's two realms that we need to consider, and one is from a CRA tax perspective, and that's covered under the Income Tax Act, and the other would be from an employment perspective. So I'm going to give you an overview of both. And from an employment perspective, we're going to focus basically on Canada today, just judging by those who have registered. We want to keep it as relevant as possible to the people that are listening. And I'm also going to focus mostly on Ontario. All of the provinces have very similar legislation from an employment standpoint, except for Quebec. So when we talk about the tests on the next slide, when I get to the employment legislation tests, that's really for all of the 8 provinces or territories other than Quebec. Quebec has specific definitions under the Civil Code of what constitutes a contract for service or an employment relationship or a contract for services, which is an independent contractor relationship. The test itself is not dissimilar to those in the other provinces. So if you are in Quebec, I still think this would be relevant, but just highlighting that it's the other common law provinces. So from a CRA perspective, that of course applies to all of us. Under the Income Tax Act, what the CRA will look at is they call it a 5-point test. I joke and say it's really a 4-point test because number one is the intention of the parties, and sometimes the intention of the parties doesn't matter. But CRA will start by looking at the intentions of the parties. What did you mean to create here? And if that's clear and both sides are clear and both sides are in agreement, that is definitely a benefit and a step forward. If from there, they'll go on and they'll look at control. So what do we mean by control? So a major difference between an employee and an independent contractor is the amount of control the worker has over their schedule, perhaps where they work, the rate that they'll charge for the work. They can refuse to work. Perhaps they'll choose the way they perform the work, or they could hire somebody else to either assist them with the work or to take the work over. So that type of control of someone who's going to come in and say, here's my rate. If you want me to do this, here's what it's going to cost you. Here's the way I'm going to do it. Here's the timeline I'll do it in, and I might subcontract somebody else out. That's absolutely looking like an independent contractor relationship. Those are things we don't do as an employee. You may, as an employee, when you join in an organization, negotiate salary, for example, but you're not negotiating the way you're going to work and how you're going to do it, and you're certainly not, or at least shouldn't be, getting someone else to do your work. And then there's also the chance of profit or risk of loss. And here, what again we're looking at, it's tied closely to control. An employee really shouldn't have much risk. An employee is going to join a company in most circumstances, is going to be provided with all the equipment and tools that they require. And as Jelaine just mentioned, you're going to most likely be provided with benefits, and all of those costs are covered. So really, other than nominal costs of maybe getting yourself to work from public transit or the gas in your car, you really don't have any expenses. And you know what you're going to make, and you're going to make that, what you're going to make day in, day out. I mean, you might have a commission structure, so there is some variable. But otherwise, you're really not at a risk, and you're not at a risk for loss. Whereas if you look at an independent contractor, they're going to sign an agreement to perform services. Well, perhaps they work from home, or perhaps they work from an office, so they could have their own rental expenses. As Jelaine mentioned, if they have any disability coverage or sick leave or insurance coverage, that's of their own accord and their own expense. The independent contractor who's going out and trying to get contracts from different companies, there's a cost of sales, the money that they expend to try to sign those contracts, and in the end, they may not get the contract. They're out that money. And not going to be able to recoup it. So as you start to look at those different factors, and quite frankly, if they don't do the job well, there's a chance they couldn't get paid. And under the contract if they haven't performed their terms, which is certainly not the case for an employee. And the third part, or fourth part, sorry, that the CRA would look at is how integral that part of the business is to the worker, or in other words, the dependency that the worker has on it. So again, an employee, there's usually a provision, especially if it's a full-time worker, that you're not to work anywhere else. You would certainly not see that or want that, and we'll talk about that in a few minutes, in an independent contractor relationship in some circumstances. But if an independent contractor is working solely for your company, is using your tools, if you're exerting some control over how they work, where they work, their schedule, for instance, maybe they have to ask you, hey, do you mind if I'm take a break next week, those types of things, and you're really their only client, that's starting to look pretty suspicious from a CRA perspective. So the best case scenario is when you've hired an independent contractor to perform services who actually has other companies they perform those services for. From what I've seen from the case law, that's actually one of the best ways to prevent a reclassification of an independent contractor to an employee. So you should be, perhaps as a company, but you could protect yourself in the contract, but as an independent contractor, definitely a little wary if you have one client and one long-term client. You'll want to make sure all of the other aspects and considerations in the 5-point test are really strong and clear and definitive, because that's quite risky. And then the last point is the ownership of tools. So again, tied into control. Usually when an employee comes, as we said, they're provided, their desk, they're provided their equipment. Here's a company computer, here's your phone, and you're off and running. A independent contractor is often not provided with those things. They may or may not work on site, and are expected to have a lot of the equipment and tools they need. Now, in today's world, especially in our now new world, with working remotely, we are in a different situation when it comes to data security and privacy issues, and also in highly regulated industries. So if you look at something like the financial services industries, you're not going to be an independent contractor with any bank in Canada and be allowed to use your own laptop. And in lots of companies, you're not going to be able to use your own laptop and then connect to the company network or system. So it is very true in some instances that the independent contractor is going to be given some company tools to use. So again, it's looking at the situation as a whole. How does it look? How does it smell, using the smell test? If all of the, if they're given their own tools, the company's exerting a lot of control, if you look at, it's the only client that independent contractor has, things will start to add up in a direction you probably don't want. So although they are individual, all of those factors are going to be looked at together as a whole by CRA when they try to make their decision. And there's an example of a contractor moving in. Thanks, Jelaine. So from an employee perspective, an employment legislation perspective. So again, you've got the CRA point of view, and then you've got the Ministry of Labor point of view about whether or not someone's an employee. And we'll talk about the consequences under both. They are different under both. But one thing that's important to keep in mind is under the employment for either one, it is not definitive if you've been classified as one or the other in the other setting. So, for example, what I'm saying is if you had a claim against you from a independent contractor to the Minister of Labor, and the Minister of Labor, you went through the adjudication process and they said, no, that person is actually an independent contractor, that would not prevent the CRA from stepping in and looking at the situation and saying, is that person an independent contractor or an employee? And they would not take the decision by the Minister of Labor and base it upon that. So you could actually have two different decisions under either or legislation. So they're very similar tests. With that said, from an employment legislation point of view, they're going to be looking at basically, is the worker in business for his or herself? So the same types of issues, the level of control that the company has over the worker's activities, is the worker providing his or her own equipment? Is the worker able to hire people to assist with their work? The degree of financial risk taken by the worker, the degree of responsibility for investment and management held by the worker. Again, all coming back to control and financial risk and reward, and then the worker's opportunity to profit from their own tasks. So again, very similar, but just highlighting that there are two different risks and two different bodies of legislation that you need to make sure you stay on side of.
Christine, before we move on, I think my understanding, and for a lot of people in HR, is if the contractor's incorporated and you're not paying them through payroll, but through accounts payable, that's a magic bullet and you don't have to worry about anything. But you're saying it also depends on the number of clients they have and so on.
Absolutely. And unfortunately, Tony, when it comes to CRA, as far as I know, there is no magic bullet in any realm. And if there is, please contact me after this presentation and let me know what it is. Yeah, unfortunately not. And that's a great point. Thanks for bringing it up, because it's a really common misconception that we've heard a lot of companies say to us, or even, smaller businesses who have independent contractors, and they say, well, we're incorporated. Yeah, that unfortunately, there is no silver bullet. The CRA won't look at that and consider it and say, okay, so now we don't have to go through the 5-point test. They're going to go through the 5-point test whether or not the independent contractor is incorporated.
Thanks.
No, thank you. Great question. So that leads us to the risks of misclassification. So if you have said they are one thing and the Ministry of Labor or CRA says they're another, what does that mean? So of course there are fines and penalties. And of course under the CRA they're much greater. But from a Ministry of Labor perspective, and I've just taken this example from Ontario, the provinces are all pretty similar. But the Employment Standards Act, your first contravention is a $250 fine. Your second contravention is $500 fine. Your third contravention is $1,000 fine. So not huge penalties from a ESA perspective, but also keep in mind if someone who you have been treating as a independent contractor is found to be an employee under the Ministry of Labor, they then become eligible for all of the benefits that employees receive throughout their period of service with you. So for example, vacation pay, depending if it was a management position or not, overtime pay, if it's a retail store or a franchise restaurant, obviously they would have had to been receiving minimum wage. So all of those benefits that come with an employee situation, you could be found to be liable for by the Ministry of Labor, plus the penalty. And the Ministry of Labor also does something a little different, where they post any company who what they call an offender. So you have misclassified a worker. They post that up on their website. Fans of public shaming as well. So, and under the CRA, there are the potential of course, any source deductions. So CPP, EI, both employer and employee contributions of EI, any of the unremitted source deductions from the date they should have been remitted. And the CRA also has a 10% penalty on the total assessment of that value, and plus interest, which is usually about prime plus 1% from the date that the contributions were due. So as you can see, and that's from a company perspective. From a worker perspective, if you have been an independent contractor, as Jelaine mentioned, and you have been deducting off your net income, your business expenses, and then paying income tax based on your net, deducting expenses off your gross, CRA will come back and refuse those deductions or portions thereof. So looking at the misclassification from a financial standpoint, it really is a significant penalty that you can occur. The other thing I'll mention just quickly, although Canada is luckily not as big on class actions as our neighbors to the south, there have been 2 instances, both in Ontario, where independent contractors, or people who were labeled as independent contractors according to their employment agreements, have been successful in joining in a class action suit. So if you have a specific sector of your business that you outsource in this manner, something to think about. The first case was in 2016 in Ontario, and these were door-to-door salespeople for an energy company, and they were found to be able to bring an action as a class. And then the Ontario Court of Appeal in 2019 just struck down a mandatory arbitration clause that existed in Uber drivers' contracts, making them all independent contractors and saying, if you have any disagreement, we have to arbitrate this issue. So the court struck that down, and what this does is it paves the way for the drivers to go to court as a group, and they're seeking reclassification as employees instead of independent contractors, and claiming damages of around 400 million. So definitely some potential serious consequences.
Hey, Christine, we were discussing this a little bit earlier, but we talk about the tax consequences for both parties, and with the independent contractor now seemingly on the hook for income tax to be payable, can they approach the employer who would just have the responsibility of having misclassified the relationship? Can they hold the employer accountable to that?
A lot of that would depend on the independent contractor agreement. They're the services agreement that you enter into. And we'll talk a little bit more about the agreement in a few minutes, but I think the idea is you want to keep that in mind when drafting your agreement. Lots of companies I've seen in a lot of service agreements, will put in a provision that states that the independent contractor indemnifies the company against any misclassification. So right. That's a pretty big deal. So if you're an independent contractor, obviously make sure you're having those clauses reviewed. And as a company, that's the kind of language you want in there, so that you could be protected. Now, if it's a small independent contractor, it may be hard for you to collect on that, depending on the amount, but definitely something that you should address in your agreement.
Okay.
There are some industries which traditionally had used a lot of freelancers, contractors, and so in these industries where you've got government grants or other kinds of grants that have a fixed date, the industry tended to hire people on contracts, and this could be either as an employee or as an independent contractor. but the funding runs out on a certain date, so the hiring was for a fixed term. The other thing would be fundraising projects, other types of project work, and the advertising marketing industry has long used freelancers, graphic designers, and others, again, typically defined by the project, the making of a commercial, the designing of a website. And so it lends itself to freelance and independent contractors. And the other one is IT for projects, managing projects, supporting projects, the delivery of a new technology. And so again, an industry that's used that. In our conversations with Christine, just because your industry has historically done it doesn't mean that you're CRA proof. It's not a reason that you can give the CRA, and so you still have to make sure you go through all of the other things we've been talking about.
Right.
Yeah, exactly. Thanks, Tony. Yeah, it doesn't matter. As I said, it doesn't matter what industry you're in. It doesn't matter what's traditionally been done. It doesn't matter if it's a fixed term contract or not. Employees can have a fixed year term contract. So whether it's grant based, whether it's not for profit, whether it's a for profit corporation, none of that, as we walked through, is part of the CRA or the Ministry of Labor test. So yeah, it's a common misconception for sure.
Right.
And I guess what I've been hearing is that if you're not sure, better err on the side of employment rather than trying to make a case later for independent contractor.
Well, I'm going to say if you're not sure, you should call a lawyer. And just make sure you get it set up properly. That's what I'm going to say. But there's definitely less risk because there's no benefit. Let's be honest. There's no benefit to CRA to reclassify somebody as an employee. So they're not, or as an independent contractor. So they're not going to look at an employee situation where they're receiving their source deductions and there's less tax write-offs available. They're not really interested in reclassifying that situation.
Okay, well, let's actually spend just a couple of minutes then and talk about how do you go about hiring an independent contractor. So if you do have that in your sights and all of the stipulations and qualifications that we've just outlined still meet your standards, let's just spend a couple of minutes here. And Christine, I like the way that you had put this earlier, where it's all about the agreement and the services agreement itself. So it's really, there's more than actually key is within the title, but it's also in the treatment. And that can be everything from cradle to grave in terms of the hiring process and how we bring people on board, but having to reflect some and really consider that we are going to be charged quite a bit more for an independent contractor. They take into consideration that that the employer won't be having to pay any of those source deductions, but generally the fees are higher by the hour. Best practice and advice, of course, as well, is if they're charging you HST, make sure you get the HST number. But even the terms of the contract itself, and Christine, if you want to jump in here again around the liability, the indemnity, exclusivity is a big one. That's another one I want to talk a little bit more about, and then the service levels. But with that exclusivity piece, we were discussing this earlier. I mean, as an employer, if I bring aboard a independent contractor and I've asked them to work a full complement, a full work week at 37 and a half hours, and I want them to exclusively work for me. So you're offside if you're, being subject to trade secrets and then working for one of our competitors. The question I had for Christine earlier was, well, if I'm deeming them as exclusive, am I not really insisting that they don't work anywhere else? Which is one of the key factors that identifies people as an independent contractor, is when they have multiple clients. So Christine, do you want to comment on that one?
Yeah, sure. I think the issue, there's a couple of different issues that you've highlighted in that, Jelaine. So one is for an independent contractor, I wouldn't recommend putting an exclusivity clause in the agreement. What I would recommend is stating that the independent contractor needs to provide 40 hours of services per week. So making it clear that this is your expectation of the amount of time towards the project or the work that the independent contractor is going to provide, but I wouldn't put an exclusivity clause. And then what I would say after outlining, here's the expectation of work, I would state that the independent contractor is free to work with other companies, but I would make a carve out that during the term of the contract, that they are prohibited from working with anyone who is a competitor. And then you would, of course, define what a competitor for your specific business was. So I think you're not doing yourself any favors if you actually write in an independent contractor agreement that the person has to work exclusively for you. Because if we go back and look at that CRA test, one, that looks like a lot of control. Two, they're 100% dependent on you for their income now. It's starting to look and feel a lot more like an employment situation.
So it can be really addressed through trade secret protection and so forth, or confidentiality.
Well, you're going to have confidentiality provisions no matter what, right? Because whether someone is an employee or a contractor, you're going to have a confidentiality agreement and non-disclosure documents that you're going to have them sign, because you're going to want to protect that either way. Although this wasn't exactly a question, but what that could also lead to is understanding the difference between intellectual property protection as well. So most employment agreements would state that, anything that you create becomes property of the company. So you'll just want to take a look at that as a sidebar here with your independent contractor agreement as well. If it is from an IT perspective and you have someone who's actually developing a platform or writing code for you, you will want to get something in there about that they assign all of those rights to you, including obviously moral rights waivers, and that kind of thing, to make sure that that's covered. But yeah, I think you just want to, and it kind of goes back to what you said from the start, Jelaine, about services agreement versus an employment agreement. And it's not just the title, of course, it's substance, not form. So no trier of fact is going to look at, oh, well, I see you have a services agreement, and not read it. And just say, oh, so that therefore it's an independent contractor. Not that you were suggesting that, but so it's really important that you take a look at those two agreements, and are able to go through, and because they should not be similar. Your services agreement to hire an independent contractor should look a lot like your vendor agreements, for anybody kind of supplying you with services. And that's how I keep that in mind. So the other buckets here, your service levels. So putting a description in an employment agreement, you're going to have a job description, but it's not necessarily in a detailed manner going to say, here are the things you have to perform. That would be in like a performance management or your goals and objectives for the year. That kind of information should absolutely be in a services agreement. You want it to be as specific and detailed as possible, so you as the other contracting party can turn around and say, hey, you haven't performed what we're supposed to be paying you for. And if you haven't performed them, and again, that's where we talked about earlier, if they haven't performed them, then you can not pay. And whereas obviously, you couldn't in an employee situation.
Right. So duties versus the services, right? Roles, responsibilities, of an employee versus the services and the deliverables, I suppose, that you need to.
Exactly. And in some project based, although I know Tony made, before we started, made the joke about IT projects never being on time. I'd argue or on budget, but those are deliverables you might want in there. You might want milestones depending on the job, right? So it's, we're hiring you to do X, Y, and Z, and here's the timelines in which we expect it to be done. So you want that kind of a detail, again, as we talked about, from a liability not just from a tax perspective, but you want to make it clear that the different risks, because there are different risks, and you'd asked me the other day, Jelaine, about reputational risks. So if you have someone attending conferences, for example, and quote unquote representing your company, how do you control that? So you want to have language in there that makes it clear that they can't do anything in bad faith, or that would impact negatively the reputation of your company. I would have in there that they can't sign any legal agreements on your behalf. Nothing in the agreement is providing them with that kind of authority. So again, it should look very different. And then the employee agreement, and I would have termination provisions. And again, the termination provisions will be night and day. You don't want to be referencing severance or notice or anything like that in an independent contractor's agreement, which obviously you want that tied down as tight as you can in an employment agreement. But with that said, you'll want breach provisions. You're going to want, if they are doing something that's offside, you're going to want breach provisions in there, like you would with any vendor, and what you can do in that instance. And then I would also say you'd want a termination for convenience right, that says, hey, we appreciate your services, but if it's not working out, maybe we'll give you for 15 days notice, maybe we'll give you 30, and we'll terminate the contract.
Well, I think it does, like you said, it comes down to how we treat them, and I found that quite eye-opening, and just this whole the optics around when CRA has their assessment of control and relationship and defining it, and I know as an organization we've been through it, where you're really offside if you try to treat an independent contractor even through an onboarding process. Like, you really shouldn't be bringing them through orientation, and you're not going to hold them to the policies, procedures, and codes of conduct. And that's what brought up the whole question about, well, how do I have any sort of management of them when they're at a conference representing us? Or even involving them in performance management, and that's why we actually took the term, the second last bullet, and we reversed it in managing performance, which I think you've touched on already, Christine. Is just really crystallizing what those deliverables are. So it's an interesting journey in how you treat an independent contractor, and what can very quickly turn them into, from an optics point of view, into an employee. So I've certainly learned a lot throughout this webcast and through the building out of this presentation.
Well, but I think you're absolutely correct. And things like, and they're easy mistakes to make, right? Oh, someone's news joining, so we'll put them through onboarding. And although everything in the employee handbook doesn't apply to them, let's pass them an employee handbook, and just so that they're aware. The idea is, philosophically, the idea behind hiring an independent contractor is supposed to be that you're hiring somebody with a certain expertise. So the idea is they're supposed to be trained. So you don't need to provide training.
Right.
And sometimes, it's not always black and white. It's like we said with tools. Sometimes, they do need to learn if they're touching, for let's see, the IT aspects. If you've got a platform that you built, if it's SaaS related or what have you, they might have to learn something specific to your business. But the idea is all of the training they already have and are bringing that with them, so they wouldn't be quote unquote trained like an employee would. And yeah, you want to be really careful. There's nothing wrong with making sure that an independent contractor abides by things like your basic code of conduct. And again, if you think of it as a service provider, quote unquote, vendor point of view, if you have a vendor that sometimes might come on site, you would very often attach as an exhibit to that services agreement your code of conduct, and say, well, any agent, employee, or contractor from the company is on site, they have to abide by all our workplace health and safety policies and practices. They have to abide by the company's code of conduct, and you provide them that. So there's nothing wrong with providing an independent contractor with those things. But I think, as you're mentioning, a common pitfall is to say, oh, well, I've got a million things to do, and those documents are inside our employee handbook. So the fastest thing for me to do is just give them the employee handbook. Because the employee handbook is probably going to outline sick leave and benefits and vacation time and all of those kinds of things that do not apply to the employee contract. And you don't want to do anything that confuses that image. But it is very different, and as you said, from the performance management standpoint, as well, for sure.
Okay, thanks, Christine. Very helpful. So I'm just observing our time. It's just going on about 2:45 at this time. And I want to jump to our very last slide, and then I want to open up for questions for our group today, our audience. We thought it was a good idea to actually bring forward a real case scenario and just give you some insights around what might be some assumptions of the amount of time that you accidentally or intentionally bring aboard an independent contractor, and then later they've been deemed as an employee. So in this case, Organization X has hired a contractor for a 3-month duration. And we know the dialogue surrounding that was that the individual who was to be receiving the contract was also told that this had strong potential of turning into a permanent full-time position, and whether that was the intention or not. But the employer chose to use, however, the contract period of what was the 3 months more of as an assessment period of performance. And so during that time, the contractor actually was, because they were on site, they were provided a phone, a laptop, and even business cards. So given the conversation today, I think we all know where this was heading in terms of CRA's assessment. But I think one of the big interesting telltales of this particular scenario is that this person didn't even make it through their 3 months. This person lasted what was upwards of about 8 to 9 weeks before they were let go, and it was actually based on performance. We were told also, though, that the amount of time and the investigation from CRA for such a brief employment relationship was extraordinary. So there were countless interviews, plenty of dialogue and phone calls and back and forth, requests for information and so forth. And I think just that the big takeaway here was the time soak. So even if it's a brief outing or a brief relationship, the process that follows can be extraordinarily difficult and long from a time perspective. So Christine, did you have any other thoughts just about this particular case study or commentary on it?
Yeah, I think it's a good point about the time that any interaction with CRA can take. And the other thing is, and I mean this with all due respect, I should have checked to see if there's anybody from CRA on the call. It's interaction, quite frankly, we all want to minimize, right?
Yeah.
I mean, you don't want to be spending any more time and resources on this stuff than you have to, and you certainly don't want to flag yourself as a company.
That's right.
Sometimes or has been found offside. So, it's a really good point. And it is amazing to hear that for a 3-month contract, which wasn't even fully performed, that was still enough to grab their attention and have them do a miscalculation. I think the only point that I would say about this particular circumstance, Jelaine, is that I think I'm not overly concerned with the fact that the contractor was provided the phone and the laptop and the business card. I think the issue here was the conversation and the idea of even though it was a 3-month contract, the idea that there would be a possibility to turn it into a permanent full-time role, and probably not on purpose, but the 3-month duration seems like a great amount of time to check somebody out and to see if it's going to be a fit and if they actually have the skills that they've purported to use. The problem with that is it matches identically the 3-month probationary period that's offered under the ESA and several employment legislation agreements in Canada and even the UK and Europe. So I think that the problem with that is what CRA would probably say is that could have been a 3-month probationary period in which you could have let the employee go if it didn't work out. But hiring somebody for a few months and then saying you could then turn into full-time employment, that's going to muddy the waters from an intention standpoint.
Right.
So once you have those waters muddied, and then you're giving tools, and then all of that kind of stuff starts to float in. But I would see that as the biggest red flag in this case study is the talk of potential full-time employment. So what I would suggest in such an instance is that might be the intent of bringing someone on as a contract. But even if you're thinking it in the back of your head as an employer, I wouldn't necessarily communicate it. I mean, perhaps in the interview process, you could say, if this turned into a longer term role, would you be interested? Something just to make sure, you have somebody who would consider such a thing. But I wouldn't have really open dialogues in the parties kind of agreement. Hey, if this works out, we're going to turn it into a full-time position. And also it just leads me to one further point that I think is important to mention. If you convert a independent contractor to a full-time employee position, and obviously not a huge risk here if it's a 3-month service agreement for the contractor period, but courts in Canada are more often than not these days looking at, when they're looking at pay in lieu of notice and severance, they're looking at the entire service period. So not just, so let's use an example. So you hired somebody in 2015 as an independent contractor. They worked for you until 2018, where both parties said, hey, this is working great. The independent contractor is ready to become an employee. You want them to be a part of the team permanently. 2020, let's just say a global pandemic hits and you have to make changes and you let that person go, you fire that person. Courts are most likely, historically, they're not going to look at them as an employee from 2018 to 2020. If it not cut and dry, obviously fact dependent, but if it was someone who was providing exclusive services from that first 3-year period, performing basically the same thing that they were, and on a full-time basis, the court is more likely than not to say you owe them pay in lieu of notice for those 5 years.
Right. Okay. Yeah,
So
fair enough.
Christine, someone was asking earlier, you were talking about not having an agreement with an independent contractor that says you're going to work 40 hours a week because they're ideally going to have other clients. Is that part of the definition around having somebody working with you full time, or giving them the option to pursue other interests, or that could be done beyond the standard 40 hours?
Actually, what Ed said was it makes sense. That's as much as I would address exclusivity in an independent contractor agreement, is to say, we're expecting 40 hours of your time devoted per week to this project. So I was saying I would put that in an independent contractor agreement, but then I would also state from an exclusivity provision that this contract is not exclusive. The company has the right to hire other independent contractors or to perform the services themselves, and that the independent contractor has the right to work with other companies and just carve out competitors. So because you may want, in reality, as we know, you may want somebody who's fully devoted to you, but as an independent contractor, not as an employee. So again, it's looking at all of the different variables. So making sure your contract is really clearly sounding like a vendor relationship contract and not an employment agreement. Making sure if they are working 40 hours, if they are working just for you, taking a look at their tools. As Jelaine mentioned, even how they're being paid, right? They should be sending in an invoice in their name or their company's name. And that invoice should be going to finance, and finance should be paying that invoice. It shouldn't be done on the payroll run. That kind of thing. Maybe they invoice monthly and people are paid bi-weekly. You'll just want to make sure you have all of the other, ducks in a row, if you do want somebody full-time devoted completely to you.
Great, thanks for that. And one other quick question, because we're running short of time, and that was, does the contractor need a history of demonstrated work as a contractor before you hire them? Is that take away some of the risk?
Good question. I wouldn't, and to be honest, I haven't come across a case where they've relied on that. So I'm just saying this from my opinion and experience. I would think that probably not, because I think CRA, I haven't seen an instance where they look at other engagements unless they're going on at the same time. So I think they're going to look at your specific fact scenario. So I think as far as saying, well, no, it's an independent contractor because look at all of the experience they have. You may be hiring an independent contractor who just left their company, as head of IT and now consults on IT. So they've never really consulted on IT before. You're their first consulting, quote unquote, independent contractor gig. But they do have expertise and experience. So I think that so I guess I'm probably saying two things. One, they're going to have some experience. So again, you don't need to train them. That's why you're bringing them in. But not necessarily lots of previous experience on doing exactly what they're doing for you. Does that make sense?
Yes, it does. We're wrapping up our hour of this webinar. Any last second comments from you and Jelaine?
Jelaine?
No, I don't think so. Again, my only big takeaway is just understanding all of the innuendo and the subtleties and differences between how I treat, not just again by title, but how I treat an independent contractor and how that can so quickly turn into the optics of being an employee. So that's a big takeaway for me.
Yeah, absolutely. And I think it's tough. And the problem is, it makes it sound really easy when you say, control and tools and, all those kinds of factors in the test. But in reality, the reality is more gray, right? So it is tough. And especially from an HR perspective and in-house counsel perspective, you got a lot of things going on. So you're probably not monitoring this as closely as you should be, as far as what does the communication look like, and is there, quote, some performance management going on when there shouldn't be, and did we give them the code of conduct in the employee handbook, and all of that kind of stuff. I think it is hard to think of it on that granular of a level in the day-to-day stuff that we're all dealing with.
Yeah, it sounds like quite the balancing act, because you want the person to feel welcome and the team to integrate and work with them. At the same time, you have to be careful as to how you position some of that.
Mm-hmm.
So some great tips today. Hopefully it will help our audience stay on the right side of the legal issues. And thanks again. You both did a great job. I really appreciate your efforts today at making it clear and concise. So thanks a lot. And as I said at the beginning, we will send you a copy of the slides, and we'll also send you a link to the actual recording if you choose to listen to it again later. Thanks a lot, and thanks for your time in joining us today. Take care and have a great and safe afternoon.